Okay, I'm back. It's after dinner time, and the 4 o'clock hearing in United States v. James Comey has occurred and concluded, and we have the judge's order. But in the lead up to the hearing, we had two more filings, one from the defense and one from the prosecution, both arguing their side, their respective positions on the disclosure of grand jury materials. And now that I have a fresh pot of coffee here, or a fresh press of coffee, because I am a coffee snob. And thank you to everybody who keeps me caffeinated. You can see my links in my profile or in the description of the video for Ko-Fi.com and or any other way that you choose to contribute to the show and support what I do. Thank you very much. I run on caffeine, and I also, your support makes it possible for me to spend so much time on Pacer and get all these documents. So thank you very much. I already did a video earlier today on what's going on in the United States v. Comey as regards the disclosure of grand jury materials and the filter protocol. Both of those issues are being handled by Magistrate Judge Fitzpatrick. He was appointed by, I don't know if appointed is the right word, actually. He was brought in by Judge Nachmanov, the district judge in EDVA who's overseeing the criminal case, to handle specifically the issue of the grand jury materials and the implementation of the filter team protocol. So if you're not caught up on that stuff, I'm going to very briefly touch on it here, and then we're going to get to those new filings because there's two affidavits in them that are interesting, and there's some new information in the filings. And we're going to get to the order that came out today. And I'm going to skip to why this is important after I sip my coffee. Here's why all this matters. This is why I've been making these videos about this specific issue. It's why in all my recent episodes I've been talking about the filter team, actually since the case came out. So since let's see, they filed for the filter team protocol on October 13th, and the indictment happened on September 25th. So since about 2 weeks into this case, I have been talking over and over again about the filter team and about the quarantine material, the potentially protected attorney-client privilege material, all of these things. The reason I keep going back to them, and I've spent so much focus on it, is because the entire future of this case can hinge on this issue. I'm not saying that the case is in jeopardy right now. I'm saying that the direction this goes could either sink the case or it could reaffirm the indictment. We know that in the response by the United States to Comey's motion to dismiss for unlawful appointment of Halligan, which I covered on my most recent full episode of Just Human podcast. And it changed my mind, that filing on the appointment of Halligan. Pam Bondi issued an order appointing retroactively Lindsay Halligan to a special attorney, and then also giving her the authority specifically to prosecute James Comey and Letitia James, and also stating that she reviewed the grand jury proceedings and the indictment, and she endorses them. Really throwing a lot of weight behind supporting the grand jury and this indictment. But there are irregularities with this indictment, and I've gone over that before. And the reason this could sink this case or reaffirm the indictment and allow it to go forward, however far it goes, is because if during the grand jury proceedings, if there was a disclosure or a privilege spill of information that was protected by attorney-client privilege, in other words, it was not legal for that information to be shared with the grand jury during that proceeding as they worked towards that indictment, and that information that was shared with them that shouldn't have been shared was in part what convinced them to return an indictment against James Comey, then that's very, very good grounds to dismiss the indictment altogether and they dismiss the case. And specifically, what is allegated here is that, and we know part of this to be true, that an FBI agent, Miles Starr, was exposed to potentially attorney-client privilege communications between Comey and person 3 in the indictment, Daniel Richman. And that guy, that FBI agent, was the only witness to testify to the grand jury. And after he testified to that grand jury, he was pulled off the investigative team that's attached to this prosecution by the Office of Legal Counsel because he had been tainted by that attorney-client privilege materials or that exposure to those things. We also know that given that it was communications between Comey and Richman, and given that this case, person 3 in this indictment is Daniel Richman, and the person indicted is James Comey, and we know that James Comey retained Daniel Richman as his own private counsel after he had been fired by Trump, it seems highly probable that that FBI agent did convey that information that was under attorney-client protection to the grand jury in this case. Now, I'm not telling you it did happen. I don't know. But there are reasons to believe that it may have happened. And if it did, that would be illegal. And that would be a violation of Comey's Fourth Amendment rights, I believe, possibly his Fourth Amendment rights, but definitely a violation of attorney-client privilege. And that would taint the grand jury because this tainted witness gave them that information, that privilege information. And it would be very good cause for the indictment to be dismissed. Now, on the other hand, if a review of this grand jury materials shows that that was not the case, and that the grand jury did not hear attorney-client protected information, and the FBI agent, Miles Starr, who testified to them and was later removed, didn't convey to them any information that they shouldn't have had in considering an indictment against Comey, well, then the indictment is not reaffirmed, but the indictment is all that much better. This issue has been it's been examined, and it has been found that there was no grounds to bring a motion to dismiss by James Comey, and the grand jury process is on the up and up. And so, as Pam Bondi has, in her order, said that she reviewed it and everything was good, well, she'd be right. And the whole thing moves forward. And then we'll see if the judge, Magistrate Judge Fitzpatrick, grants a protocol for a filter team to come in and do what should have been done a long time ago. Then there we go. We're off. And the case moves past this issue. It's settled, and the next thing comes up, you know. But this is a critical juncture, I think it's fair to say. So, the hearing, there's always so much background to catch up on this thing, but I feel like it's always worth it to get the perspective of what's going on here, to get the context of what's going on here. It's so easy with any criminal case, whether it's Trump or Comey or anything else. If you just take a snapshot, if you just look at what happened that one day, it's really easy to make a fire from the hip, you know, half-assed assessment of the thing and say, oh, well, so-and-so's crooked, or so-and-so's bought off, or so-and-so is doing whatever. And you know, and it's a baseless accusation. It's not an informed position. It's much better to have the full context of it. So, all right. So these are the two motions they filed. You can see they refer 168 was the order for today's hearing. And so these two filings come in. I said motions. They're not motions. They're briefings. I just gave you the background. I have a couple threads on the background. Here's the video. Judge in Comey case orders DOJ to turn over Arctic Haze and other material. Okay, so going in, defense believes that irregularities with how the indictment came about, particularly the possibility of an FBI agent giving information to the grand jury that ought to have been shielded by attorney-client privilege protections, warrant disclosure. Such a privilege spill and or other irregularities could provide a basis for a motion to dismiss the case. And I have a rundown on those irregularities right here. It's possibility of multiple constitutional violations, but also the indictment misstates the exchange between Cruz and Comey, so it has a factual error. The indictment misrepresents what Cruz's line of questioning of Comey was. Cruz himself misquotes Grassley's questions in his questioning of Comey. The circumstances and questionable lawfulness of Halligan's appointment, which I do think is lawful, but there's questions about it, and other U.S. attorneys have had legal trouble recently, Haba and a couple others. Halligan presented the case to the grand jury alone, only on her fourth day ever as a prosecutor, and the custom is typically that a line prosecutor presents the case and then the U.S. attorney for the district signs off on it, not that the U.S. attorney presents it. The presentation returned a no true bill, meaning a failed indictment for a 3-count version first, and then she kept them there an hour and a half late or so, and then they returned a 2-count indictment. Halligan signed both, or at least signed one, but her signature was attached to both, which she then filed in the docket, which confused the magistrate judge because that's not something you do. And then the agent who served as a witness to the grand jury may have been exposed to attorney-client privilege material, and he then presented that to the grand jury, possibly. And then that privileged information appears in the indictment, it seems, anyway. Those are the irregularities. Now, the prosecution, from their side, they're arguing naturally that the defense is just speculating, though they do acknowledge that an FBI agent was pulled from the investigative team after he was exposed to privileged material. So there's truth to that. So that gives weight to Comey's team and what they're arguing. Prosecution also spends time arguing that even if there was a Fourth Amendment or a privilege violation, it's not grounds to dismiss. And I got to be honest, the fact they're not arguing that this didn't happen, this isn't a thing that didn't happen, comes across like they're hedging to explain away what happened. Interestingly, they address whether the grand jury was told of attorney-client privilege information, which is material they are also seeking a filter team protocol for, and is material that only the only witness in the grand jury heard from, the FBI agent was exposed to and was later pulled off the case because of that exposure, by arguing that it wasn't attorney-client privilege information. The prosecution in their filing is saying, yes, there was an FBI agent who was exposed to potentially attorney-client privilege information. He was later pulled off the case. Has nothing to do with it. He's also the same guy who testified to the grand jury. But the information he presented to them was not attorney-client privilege information, and he wasn't tainted. Well, if that's not the case, then why was he pulled off? Why did the Office of Legal Counsel advise for him to be pulled off? If it's not attorney-client privilege material, then why is it quarantined? If it's not attorney-client privilege material, then why are you asking the judge for a filter protocol, which is why this judge is here in the first place? The whole reason Judge Fitzpatrick is holding hearings and deciding anything in the case is because prosecution came forward on October 13th and said, hey, we can't turn over all of the Rule 16 evidence we have against Comey because some of it may be attorney-client privilege material that we got pursuant to 4 search warrants served on Daniel Richman after Comey had retained him as counsel. And so we need a filter team to review those things to see if it's attorney-client privilege. Comey can assert his right that it's protected material, and then a judge can see if there's an exception to that attorney-client privilege, such as the crime-fraud exception. But if it's not attorney-client privilege information, then why are we even here? Regardless, they say, the burden under Rule 6E is for the defense to produce particularized and factually based grounds for grand jury disclosure. And they argue that burden is not met here. Instead of turning the material over to the defense, the prosecution requests that the judge review the grand jury testimony in camera, meaning privately, just him, and see for himself that everything's on the up and up. Comey's filing's here. Prosecution's filing is here. They also include 2 affidavits, each from a different FBI agent who worked on the investigative team. But neither one of them is the agent we most want to hear from, this Miles Starr guy, who's the one witness, the only witness who spoke to the grand jury. Why don't we have an affidavit from him where he's saying, yep, I didn't get into my mind at all any attorney-client privilege information, and I didn't convey any attorney-client privilege information to the grand jury. Instead, we have 2 affidavits from 2 FBI agents who are telling us about the quarantining of this search warrant information, their reception, they're going to the file cabinet and getting out the Arctic Haze material and being assigned to look at the Blu-ray disc, and then how this other agent, who they don't have an affidavit from, found communications which may be attorney-client privileged, and they were like, oopsie, we got to quarantine that, and then he gets pulled off. All right, so this is going to be a shorter video. I'll go through these documents page by page in my upcoming episode, Just Human, episode 353, I believe it'll be. But at the briefing, this is what happened, okay? At the briefing this afternoon, Judge Fitzpatrick agreed, after a pretty brief telephone call, which was open to the public, by the way, which I appreciate. Judge Fitzpatrick agreed with the prosecution's proposal for an in-camera, that means the judge himself is going to look at it, an in-camera review of the grand jury material in lieu of ordering their full disclosure to the defense. So before Comey's team gets the grand jury material, the judge is going to look at it first and see if there's a reason, there's a basis for the defense to get a look at it. He also will permit the defense to file a submission ex parte, which means the prosecution won't get this submission, just the judge will. That ex parte submission is going to detail what the defense thinks the problems or violations may be in the grand jury proceedings. If the grand jury was tainted by information it ought not to have legally been privy to, and that information led to the indictment going through, then the case likely will be dismissed on such grounds. And it should be. And the reason I say it should be is the same reason I would say it should be in any case where something like that happened. It doesn't just matter that justice is achieved. It matters that justice is achieved in a just way. It doesn't just matter that you do the right thing. It matters that you do the right thing in the right way. And our pursuit of justice and the ends of justice should be to also pursue the means of justice being conducted in a just way. That should be our aim. It's not enough. In fact, it falls far short of the ideal of justice to say, whatever, don't care, so-and-so's a bad guy and I want them in prison. No, there's a right way and a wrong way to go about this, and it matters that it's gone about in the right way. So if the grand jury proceeding was in some way legally flawed, it doesn't matter who the defendant is, the case should be thrown out. Whether it's you, me, Comey, Trump, whoever. However, if this indictment, if this did not occur, if the grand jury was properly conducted, it's legally sound, then the indictment will stand and the case will go forward. And to be honest, I hope it was gone about in the right way. I think it would suck if, to put not too fine a point on it, I think it would suck if this thing gets thrown out because of some sort of error with an FBI agent in the grand jury process. It's going to be bad for Halligan. It's going to be bad for Pam Bondi. It'll be bad for the EDVA. We won't get to go as far in this case and actually find out if James Comey really did approve Daniel Richmond to anonymously leak information to the New York Times or any other outlet where this whole thing would stop. The search warrants probably wouldn't be unsealed. That we won't get the Durham memo. We won't get the 1A package and all these other things from the media leak investigations. It'll be less disclosure of all of those things. And yeah, it would just suck. It'd be a mess. It would be much better if it was gone about in the right way. Everybody did their job and they did their job well. And this whole case can, instead of hinging on some sort of violation like that, falling apart because of that violation, the case will instead be decided by a jury, by the evidence in the case, by the testimony, as it should be. And I hope that's what happens. I hope that this is not, I hope in the judge's review of the grand jury material that he is not fined that there was some sort of screw up.